Hi, my name is Nathan Chapman, and I'm excited to tell you about my new book, written with Michael McConnell, called Agreeing to Disagree: How the Establishment Clause Protects Religious Diversity and Freedom of Conscience. It's about one of the most important but misunderstood provisions of the United States Constitution, the Establishment Clause. That clause is the first provision of the Bill of Rights, and it says that Congress shall make no law respecting an establishment of religion. A lot of people summarize this as a guarantee of the separation of church and state. And separation is one part of what the clause does, but it isn't even close to the whole story. My book argues that the clause is an attempt to use constitutional law to solve a really challenging problem, the problem of religious pluralism. Since the beginning, Americans have always reflected diverse religious traditions and groups that don't always support the same public policies. Throughout modern history, such diversity has often led to one group trying to use the government to enforce religious conformity, partly out of the belief that the religion is true, but also partly out of the belief that having one dominant religion would stabilize society and reduce conflict. But Americans took a different path. The federal government and the states separately decided to abandon government attempts to induce religious conformity. The result would be that religion in general, and any religious belief in particular, would flourish or decline depending on whether people chose to adopt it. Generally speaking, this has been a good thing for religion and for social stability. How to understand the Establishment Clause remains a pressing issue for American constitutional law. Not everyone agrees with my view. For many years, the Supreme Court didn't, and many scholars and activists on both sides of the political aisle do not. The first part of this talk is going to give some examples to show why the Establishment Clause remains a crucial part of American constitutional law. I'll then explain why my book makes an important contribution to understanding the clause. And then towards the end of the talk, I'll provide a brief preview of what you'll find in the book. First, what's at stake? The Establishment Clause doesn't always get the same press as other constitutional rights, such as rights to own and possess firearms, the right to abortion, freedom of speech, equal protection of the law, rights against discrimination. But once you see the sorts of cases that raise an Establishment Clause question, it's pretty easy to see what's at stake. So consider the following kinds of cases. May a state legislative body or a town board open its legislative session with a prayer offered by a chaplain? May the federal government fund chaplains for the military? May states provide chaplains for prisons? What about for students who attend public schools? May the government have the motto of "In God We Trust"? May it use crosses as a memorial for those who die in war? May it erect displays of the Ten Commandments in courthouses? What about in public school classrooms? May the government provide the same financial support for private religious schools that it provides for other private schools? May the government lead students in prayer or Bible readings in public schools? May a public school teacher pray or read the Bible at school on his or her own free time? May the government allow some people a pass from obligations, like being drafted for war, when those obligations conflict with the citizens' sincere religious beliefs? As you can see, these are tough questions, and they're important questions. A lot of them are deeply contested even today. In the past few years alone, the Supreme Court has held that a state may not fire a football coach at a public school because he prays publicly at the 50-yard line after games. It is also held that the government may honor the dead from World War I with a large memorial, even though it's in the shape of a cross. It's also held that states don't have to fund private schools, but when they do fund non-religious schools, they've got to provide the same funding for religious ones. At the same time, the court has repeatedly upheld laws that accommodate the religious exercise of minorities, public employees, and even in corporations. And there are live issues too. In the past year alone, several states have enacted or have sought to enact laws that would require public schools to display the Ten Commandments in every classroom, to fund religious chaplains for public schools, and to fully fund religious charter schools. All of these are politically controversial decisions, and they raise serious questions under the Establishment Clause. Agreeing to disagree argues that the clause is best understood to prohibit the government from inducing religious conformity, that is, from using carrots or sticks to incentivize people and groups to adopt the government's perspective on religion. This sets it apart from the other ways that many scholars and judges perceive the clause. One view that has always been influential is that the clause requires strict separation of church and state. Separation captures something important about disestablishment. The founding generation had lots of experience with the government privileging one Christian denomination over all other religions. But that privilege also came with costs. The government also controlled that denomination. In England, this was the Church of England, and in the New England colonies, it was various forms of Puritanism and Congregationalism. In some ways, too, the institutional church had some control over the government. One of the key features of disestablishment was to make sure that the government did not control the church and that the institutional church did not directly control the government. So for this reason, some Americans have supposed the Establishment Clause should be interpreted to prohibit the government from providing any sort of support to any religious group at all, and that perhaps individuals in religious groups should have no say over politics. For a while, the Supreme Court held that the government could not provide even modest support for religious schools to supplement their health and basic secular education programs, even when the government did the same thing for non-religious private schools. Likewise, some people think the clause prohibits the use of virtually any religious symbol by the government. Maybe it requires the government to get rid of "In God We Trust" as a motto, even when the symbols don't really coerce or induce anyone to change their religious beliefs, because they seem to align the government with one faith. The problem is that strict separation was never the purpose of the clause, and it isn't really possible. The founding generation was probably more religious than Americans are today. President Jefferson, while saying on the one hand that the clause required the separation of church and state, still allowed churches to use the Capitol building for worship services, and he attended some of them. Jefferson also helped to draft a seal for the United States after the War for Independence, putting Moses front and center with the rod, parting the Red Sea. It was a tribute to winning the War of Independence over Great Britain. And this was Jefferson, right? He was one of the least conventionally religious members of the founding generation. But he didn't think separation meant strict separation. Just as importantly, strict separation is impossible to implement in our society. America is a democratic republic. It's run by people who have all sorts of religious ideas, and those ideas shape their views on public policy. Religion is inevitably going to influence the government, not directly through religious institutions, but through the people, the voters, the officials who make governmental decisions. And at the same time, the government is increasingly everywhere, right? It regulates behavior in all sorts of life, and it provides all kinds of valuable services. It's intertwined with virtually every facet of life for organizations and individuals. Right? If the government is supposed to be entirely separate from religion, does that mean it can't provide police and fire services to churches, synagogues, mosques? Does it mean the government can't tax them? Or does it mean that it has to tax them? Because otherwise it would be supporting religion. Does it mean that the government can't provide welfare services to employees or retirees of churches? When the government requires some people to serve in the military, would it violate the ideal of separation for the government to exempt those who have conscientious objections? On all these things, the Supreme Court has repeatedly said that government doesn't have to be strictly separate from religion. In fact, it can't be, for reasons I just suggested. Take taxes, for example. Taxing churches would give the government tons of power to regulate them, to control them, to impose costs on religious groups. But on the other hand, not taxing them seems to give them a fairly special organizational status in our society, akin to other nonprofit organizations. On the surface, one seems to hurt religion, the other seems to help it. Which one does the Establishment Clause require? Right? Strict separationists would say the government should always keep religion at arm's length. People should be free to do what they like in private, but the government should basically ignore people's private religious beliefs and conduct. That's not the path the Supreme Court has generally taken for reasons we talk about in our book. But that doesn't mean that anything goes. Let's take a look at another popular view of the Establishment Clause, one It's at the other end of the spectrum from strict separationism. That view is that the clause prohibits the government from promoting one religion above others. The target of the clause in this view was a national establishment like the Church of England. But the government can generally support religion, even a generic form of Christianity, so long as it doesn't just privilege one denomination like Baptists or Catholics or Presbyterians or even Sunni Islam. Like strict separationism, this view has some basis in the founding. Right? It's true that an establishment of religion did prefer one denomination over others, and that disestablishment eliminated that preference. But the founding generation didn't mean to just substitute an establishment of a broader view of Christianity for an establishment of a narrower denomination. The vast majority of Americans were Protestants, and Protestantism certainly influenced the laws and the government. But the trend through the 19th century was for the government to have less and less to do with regulating or privileging any sort of religious exercise or religious organizations. Right? Religion could influence laws and policy through voters who were religious, but it couldn't use the mechanisms of government to make people conform to one view of religion, whether that was one denomination or one religion more broadly conceived. Now, there were some important exceptions, some ways in which the federal government and the states, in my view, failed to live up to this ideal. One of those was by coercing Native peoples to adopt religion. This happened increasingly, especially after the Civil War. But another was by using public schools to teach a basic form of Christianity that most Protestants would accept, but that left out Catholics, Jews, and other people of faith, to say nothing of non-believers. In fact, many public schools continued that practice, while most states refused to provide any support to Catholic private schools until the 1960s, when the Supreme Court said that the practice of supporting religion in schools violated the Establishment Clause. On this score, we think the court was right. Those who read the Establishment Clause to permit a generic establishment of religion are wrong. Right? The reason is that public schools are the main site that the government uses to shape the beliefs and habits of people. Right? Most students don't have a choice about whether they attend such a school. And when the government leads prayers and Bible readings, it strongly influences those students' beliefs and practices. In fact, that's exactly why supporters of school prayer and now Ten Commandments displays and public school chaplains want to return to a generic establishment, right? They want to shape the beliefs and habits of students to conform to their preferred religious views. Although that's at a higher level of abstraction than a preference for one denomination, it's still an attempt to achieve what disestablishment was meant to end: government attempts to induce religious conformity. So, agreeing to disagree argues for an understanding of the Establishment Clause that is somewhere between strict separationism and a generic establishment of Christianity, or even religion in general. The point is to ensure that people adopt religious beliefs and engage in religious practices with as little influence from the government as possible. This doesn't mean the government has to protect them from the religious views of their neighbors, or that those views cannot influence public policy, right? So long as the policy is not an establishment of religion. It only means that the government isn't stacking the deck in favor of one religious view over another. This means the government can support religious welfare services to the same extent that it supports non-religious welfare services, whether they're schools, adoption agencies, or homeless shelters. It means the government can't keep employees from practicing their religion on their own time in the workplace, but it can and must keep them from pushing others to join them. The government can solemnize official events with a prayer, so long as it isn't picking and choosing one religious tradition over another, and as long as it doesn't make anyone join in against their will. Let me close by offering a quick tour of how the book makes its case. It's meant to be accessible to folks who know a lot about the Establishment Clause and to folks who are entirely new to the topic. The first half tells the story of disestablishment in the US, and the second half tells the story of the Supreme Court's enforcement of the Establishment Clause since the mid-20th century. Right, the history portion of the book doesn't just provide the who, what, and where of the clause, but it also provides the why. Many readers are going to be surprised to learn that many of the most religious, most evangelical sections of America were those who were the most supportive of disestablishing. Right, their arguments in favor of disestablishment were not only about fairness, but they were religious. Right, but they believed that true religion required freely chosen beliefs and practices, so the government should stay out of it. On the other hand, those who supported establishments usually did so on the basis of what they thought was necessary for good governance, right? Republican government requires civic virtue. Civic virtue comes, they argued, from widespread religious belief. The book discusses the most important stages of the history of disestablishment. So, the features of an established religion, the adoption of the Federal Establishment Clause in the US Constitution, the movement for disestablishment in each of the states, and then the application of religious freedom against the states with the enactment of the 14th Amendment after the Civil War. The book then turns to discuss the various contexts in which the Supreme Court has applied the Establishment Clause. Each chapter provides more historical background for each context and provides a critical tour of the court's major decisions in the area. On the whole, we conclude that the court is generally on the right track, but we disagree with folks who think the court is too accommodating a religion on one hand, and others who think the court has basically given a green light for novel forms of generic establishment on the other hand. So the conclusion is brief, but it suggests something that I hope will be provocative for many readers. The Establishment Clause, of course, is about attempting to address the dangers and temptations of religious pluralism in particular. It proposes agreeing to disagree about matters of religion. But perhaps the history of disestablishment in the US could provide a blueprint for addressing some of the moral and ideological pluralism that we see today. Right? American politics is currently caught up in a war among multiple constituencies who want to use the government to shape the ideological commitments of current and future generations. Maybe a possible solution is a new level of tolerance and government non-interference that allows those groups and their constituents to succeed or to fail in the marketplace according to the attractiveness of their beliefs, rather than according to the ability to use the government to foist them on cultural and ideological minorities. Thanks so much for letting me tell you about my book. Thanks to my co-author, Michael McConnell. We'd love for you to pick up a copy of it or download an Audible version of it. Thanks very much.